A little bit about why right to work is good and what it's done for the community. I'm going to talk a little bit about the lawsuit. I think everybody knows that there has been a lawsuit, but I'll give a little bit of background and then where we're going from here, and also what our major theories of the case are. So 12 counties in Kentucky have passed right to work. And when Hardin County passed its right to work ordinance, 9 unions joined together and brought a lawsuit in federal court in Louisville. So they brought a lawsuit, and we have fully briefed it to the district court, and the district court has set arguments for August the 4th. The parties are, as I said, 9 unions as plaintiffs. The Hardin County is the defendant, and then there are a number of what we call amicus curiae interveners. So that's people who are not part of the case, not parties to the case, but who are telling the court, here's how we think you should decide this matter. And those amicus are the Kentucky Attorney General, obviously who's running for the governor, the Kentucky Senate President, Robert Stivers, the National Labor Relations Board, the Kentucky AFL-CIO, and all of the remaining counties, the 11 other counties that have passed the right to work ordinance. So the court will hear oral arguments on August the 4th, and then take it under submission. Will likely not rule that day, but we'll go back and study the issue, and we anticipate a ruling by early fall. So that's kind of the background of the case. So what's our theory of the case? The legal question, simply stated, is whether counties can enact right to work ordinances under Section 14B of the National Labor Relations Act. The National Labor Relations Act says that state and territorial law can enact right to work law, and so the question is whether or not Warren County, Hardin County, and the others, whether they're allowed to do that. And we think that the counties can enact right to work ordinances for 2 main reasons. The first is that there was never any preemption, and I'll briefly go into what that means. And then the second is even if there were preemption, the allowance by Congress of state laws to enact, or state authority to enact right to work laws, includes the right of counties to do so. So the first one is there was never any preemption. Now, let's go back to first principles and remember what we know about the Constitution. The Constitution, the 13 colonies came together and established the federal government. And they gave the federal government enumerated powers. And anything that was not given was reserved to the state. A few years later, Congress enacted the Bill of Rights to clarify what it meant, or what was meant when the Constitution was passed. And the 10th Amendment says that anything that is not taken or given to Congress is preserved or reserved to the states. So we know that before Congress got involved, states, and to the extent that states allow counties could enact right to work laws. So what changed? The default is states can do it. So something had to have changed to take the power away from counties and states to enact right to work laws and ordinances. Well, the unions say 2 things changed. One, in 1934, Congress enacted what's known as the Wagner Act, and they say that Congress, in regulating the field, if you will, regulating the issue of labor relations, pulled the authority away from the states. Well, that's an interesting proposition, but the United States Supreme Court in 1948, in a case called Algoma Plywood, said that's not true. There were 12 states that were right to work right after the Wagner Act. And one of the states, Wisconsin's right to work law, was challenged. And the United States Supreme Court said the Wagner Act didn't remove the authority of states to enact right to work ordinances or laws. So it didn't change the default. So the unions then they say, well, the Taft-Hartley Act that was enacted in the late 1940s removed the right of, or the power of states and counties to enact these ordinances, these laws. The problem with that is the House report, the Senate report, and both sponsors of the bill, Senator Taft and Representative Hartley, all said to the contrary. The Joint Committee report said it was never the intention of the National Labor Relations Act to preempt the field. What this means is that the National Labor Relations Act, though it regulated labor relations in a lot of ways, did not mean to remove the right that had previously existed of the states to enact right to work laws. And so why did Congress enact 14B, Section 14B at all? Section 14B is the section that says, it clarifies that state or territorial law can outlaw union security clauses or provide for right to work allowances. Well, the reason that they did so, the Joint Conference Committee report stated, was to make it certain that there should be no question about this being that the states retain the authority. So there's no preemption. But even if we're wrong on that constitutional argument, even if there were preemption, or even if there is preemption, which is to say that Congress removed the authority, then Congress clearly gave it back to the states, even using the union's own argument. Because the language of the statute says that nothing in this act shall be construed as authorizing the execution or application of agreements requiring membership in a labor organization as a condition of employment in any state or territory in which such execution or application is prohibited by state or territorial law. So clearly, even if you use the union's own argument, 14B gives the right to the states to enact right-to-work laws. It's our proposition that county laws, county ordinances, is nothing more than state law. Let's go back to first principles again. What are counties? Counties don't just exist, they're created. And they're created by the states. They're just part and parcel of the state's sovereignty. There's a strong argument that can be made, we're making, that Congress could not have said counties within Section 14B that the unions rely on. And the reason that Congress couldn't have said it is because Congress has no power to empower counties. They can't go there. The U.S. Supreme Court has stated it a number of times. We talked about the 10th Amendment, but in New York versus the United States, the United States Supreme Court said that Congress cannot require the passage of state legislation to affect its goals. In the Prince case, the U.S. Supreme Court said Congress cannot, quote, conscript state officers to do its bidding. In the Gregory case, the U.S. Supreme Court said that Congress cannot set the qualifications of state officials. And perhaps most directly, the U.S. Supreme Court in the Highlands Farms case said the distribution of powers is a state issue to which Congress has no business getting involved in. State law includes rights of states to enact laws as they see fit. It's clear that Kentucky or any state, Kentucky, could pass a right-to-work ordinance. The unions don't even contest this. They could pass a right-to-work law that says this applies to Louisville and Lexington and maybe apply to those counties on the I-65, but they don't apply to the mountain counties. The General Assembly all the time enacts laws that apply to some places in Kentucky and not others. Well, they did it here too. Mr. Waters, my friend, was talking about the Home Rule Act. The General Assembly, recognizing in the 70s, recognizing that not all sections of Kentucky are the same and need the same policies, enacted the Home Rule Act. And in doing so, the General Assembly says, okay, Pike County, okay, Warren County, if you want to enact something that works for your county that might not work in other counties, you can do so, provided that it meets one of a number of criteria, and two of which the right-to-work ordinances meet. And that's advancing economic development and regulating commerce. So, and this is not a novel proposition. The United States Supreme Court has interpreted many statutes to say that the word state includes political subdivisions. The City of Columbus case, the Mortier case, and many others. In the Mortier case, the U.S. Supreme Court said, and I quote, "The term state is not self-limiting, since political subdivisions are merely subordinate components of the whole." Close quote. And this is common sense, right? There are scads of congressional enactments that prohibit states from doing something, preempt states. And they say, such and such law preempts states from passing laws to the contrary, or laws even on the subject. They don't say states and political subdivisions, or states and counties. But no one would make the argument that in that area, that the state, while the state cannot enact a law to the contrary, a county could. It's patently absurd. And so it's the same argument that we're making in this case. We think we will prevail. The highest court to have addressed this issue is in the 10th Circuit And in that case, I think I'll close with this. The 10th Circuit very succinctly wrapped it up in saying and finding that Congress did not preempt the field on right-to-work law. And the 10th Circuit said, what Congress has not taken away, it need not give back. And in that case, the court allowed the right-to-work ordinance to stand, and we believe that this court will do the same. Thank you.